Hello everyone, I hope that you are all doing great. In this video, allow me to discuss certain ways to own real property or rights in real property as a foreigner in the Philippines right after this. How can a foreign citizen own real property in the Philippines? Well, you might say that it begs the question, can foreigners own real property in the Philippines? The answer is yes, under certain conditions. First, foreigners can own real property such as land in the Philippines through hereditary succession. That means to say, if you are a foreign citizen, but you are an heir to a deceased landowner, you can inherit such land in the Philippines. It must be made clear, however, that when we speak of hereditary succession, we mean intestate succession. Intestate succession means that you inherit the property by operation of law. That is, you are considered as a legal heir of the decedent or deceased person. You must be one of those identified by law as an heir. Can you inherit the land if you are named as an heir in the last will and testament? The answer is no, unless you are at the same time a legal heir entitled to inherit by operation of law. So, if a foreigner buys a piece of land in the Philippines and have it registered in the name of a Filipino citizen, a dummy, and require that dummy to execute a will in his favor to eventually transfer the ownership of the land to him, that will constitute a circumvention of the law and that cannot be given effect. So remember, a foreigner can acquire land in the Philippines by intestate succession, but not by testamentary succession. So if a foreigner is married to a Filipino citizen on whose name a piece of land has been purchased and registered, and that Filipino citizen dies, the foreigner can inherit from the deceased spouse. Second, a foreigner can acquire real property in the Philippines in the form of condominium units. Under the Philippine law, the limitation for foreign ownership in a condominium is 40%. As a foreigner, you can buy and own a condominium unit in the Philippines under your name. Third, a foreigner can indirectly acquire real property in the Philippines through a corporation. I mentioned indirectly because, strictly speaking, the foreigner does not acquire the ownership in this case. It is the corporation that is considered as the owner of the property because a corporation has a separate and distinct legal personality. However, you need to be mindful that foreign equity in a corporation for purposes of acquiring real property in the Philippines is also limited to 40%. So you would need to have a Filipino citizen or citizens as your counterpart owning at least 60% of the corporation for you to do that. As a foreigner, you may want to settle for certain rights only to a real property short of ownership. For example, you may enter into a contract of long-term lease for a piece of land which accords you the right to possess and use such property perhaps for a period of 25 years, renewable for another 25 years. The prohibition on ownership pertains only to the land. Ownership of the improvement to the land, such as a house or a building, is not covered by the prohibition. And when it comes to foreigners who are former natural-born Filipino citizens, meaning natural-born Filipino citizens who were naturalized in a foreign country, we have two laws that allow you to acquire lands for residential and business purposes, subject, however, to size or area limitations. For residential purposes, as former natural-born Filipino citizen, you can acquire up to 1,000 square meters in the case of urban lands or 1 hectare in the case of rural lands. In case you already own urban or rural lands for residential purposes, you may still be allowed to be transferee of additional urban or rural lands for residential purposes, which when added to those you already owned shall not exceed the maximum areas authorized. If your purpose in acquiring the land is for business, you are entitled to acquire a private land up to a maximum area of 5,000 square meters in the case of urban land, or 3 hectares in the case of rural land, to be used for business or other purposes. But if you already own urban or rural land for business or other purposes, you may still be allowed to be a transferee of additional urban or rural land for business or other purposes, which when added to those you already owned shall not exceed the maximum areas authorized. For former natural-born Filipino citizens, if you want to get away with these limitations, then perhaps becoming a dual citizen may be a good idea. I hope that you have learned something from this video. Please feel free to share this video to others, and feel free also to leave your reactions in the comment section below. And don't forget to subscribe and hit the notification bell icon if you haven't done it yet, so that you will get notified of our future videos. Always remember, ignorance of the law excuses no one from compliance thereof. I will see you in my next video. Ingat po kayo.